Welcome to the Judicial Committee of the Privy Council. We are today on the second day of the hearing of an appeal in the matter of Friedland and Hickox, and we are in the middle of the submissions of Miss Small-Davis on behalf of the respondent. Miss Small-Davis.
Thank you, Millard. And so yesterday I had just been at the point of taking your lordships to the section of the High Court, the first instance judgment of Mrs. Justice Lord George Creaky, as she then was. And this is in the context of the submission that your lordships heard made by my friend Mr. Phillips yesterday repeatedly, that the case was dealing with the validity of the registration of the charges. And if you look at page 253, that is a section of the judgment which deals with LIR's counterclaim. And as you will see there, paragraph 117, LIR was in fact attempting or seeking a declaration, an order, setting aside the three charges on the basis that in the case of the first two, primarily that they were the loans which they were security for were void for want of authority, and in the case of all three, that they had been registered in breach of the settlement agreement. And in paragraph 117, Justice George Creaky records the fact that the submission of LIR on the third charge was the standby loan agreement upon which for which it stood security was not an issue. There was no issue relating, no challenge to the standby loan agreement, but that third charge, along with the other two, were being set aside, were sought to be set aside on the basis of breach of the settlement agreement. So it was not a question of the validity of the registration of the charges per se. It was on the basis of Hickox's breach of the settlement agreement by registering those charges. And the learned judge in that case, in the High Court, accepted the mediator's finding, as he made in his final award, that there was a breach of the settlement agreement. I've already taken your lordships through clause 6C of the settlement agreement, which recognizes the I would say unregistered charges that were in favor of Mr. Hickox amongst others. And in reading it over again this morning, I just want to point out another line of that clause C, which says that not only the charges executed prior to the date of the settlement agreement, but it also says, or to the extent any such future charges are required in connection with the refinancing of such debts. So it contemplated that even future charges were going to take precedence over any charge that Friedland would have been entitled to register on LIR's property as security for the collateral. Be that as it may, the mediator made his finding, which everyone has accepted as final, that there was a breach of the settlement agreement. And in paragraph 118 of the judgment, Justice George Creaky cites the finding of the mediator, and she was also aware of the final award as well as the amplification award. As your lordships have seen, paragraph 2 of that amplification award required the parties, directed the parties that it should be drawn attention to the court in any proceedings in Anguilla. Therefore, what we know about the judgment and this is directly related to the questions that have been posed to Mr. Phillips, that the Anguilla court, both the High Court and the Court of Appeal, deemed the effective date of the charges to be the 16th of September 1997. And they did so in consideration of the mediator's final award and his amplification award. The amplification being the manner in which the mediator more fully explained the processes that as a result of the sale of the shares to Mr. Friedland, that Mr. Hickox was no longer an insider. He was no longer a party to whom Clause 19 related, and he was therefore free to re-register the charges subject to Anguilla law. And that's a key part that I don't think that your lordships have heard much argument on, that the mediator recognized that it was a matter of Anguilla law how the charges should be dealt with in light of his pronouncement in paragraph 4 of the amplification award, that this was all subject, paragraph 5, that Mr. Hickox is no longer restrained from registering his charges, is free to do so, subject only to the requirements of Anguilla law. And of course, the Anguilla law position of the court, the two courts, the High Court and the Court of Appeal, was that Mr. Hickox was not required to deregister or unregister and re-register, but he should simply applied a deeming date. And my Lord Boris asked that question. Perhaps it was a question that it would be absurd to use that to proceed along the lines of unregistering and re-registering. And in fact, that was the same point made in the Court of Appeal by the Court of Appeal during the course of the hearing of the appeal, which is during the course of the hearing, the judgment of which is the subject of this appeal. And so if we look at the word of Justice George Creaky set out towards the end of paragraph 118, over on page 1254, they are quite clear what the ruling of the court was, having taken into account the mediator's amplification award. And what another interesting point that I think is probably appropriate to make here is that this, of course, was a suit brought by LIR at the time when Mr. Friedland was in control of LIR against Charles Hickox. I'm sorry, Mr. Hickox filed the suit to pursue the debt as he had been required to do by the final award. And in that, LIR counterclaimed, seeking the setting aside of the registration of the charges on the basis of there being in breach of the settlement agreement. Mr. Friedland never sued in his own capacity until now in 2012. And interestingly, I would submit that the damage, any damage that was sustained was not damage to by Mr. Hickox's breach of the agreement, was not sustained by LIR. LIR was actually the asset that was the subject of the dispute between the two. And so the registration of the charges against LIR's property in breach of the settlement agreement, that breach would not be, in my submission, damage to LIR. When Mr. Friedland filed this claim in 2012, he pleaded for a strikeout of the registration of the charges on the basis of their being invalid and of no effect. And if your lordship should look at page 52, paragraph at page 51, which is paragraph 10 of the amended statement of claim, you will see that the original pleading was that the registration of the Hickox charges was invalid and of no effect, and the defendant was not entitled to rely on the registration of the Hickox charges. There had been, as part of the background to this matter, their summary judgment had been entered in favor of the defendant, Mr. Hickox, by the master back in 2015, I think it was. And there was an appeal from that summary judgment. And one of the points that was taken then that in any event, that such an action would be statute barred, it having occurred since 1997. And it was in concession to that point, I believe, that the amendment was made to the statement of claim to now recant from the position of saying the registration of the Hickox charges was invalid and of no effect. So that once we're hearing that the previous action filed by Charles Hickox against Leeward Isles Resort had to do with the validity of the registration of the charges. The court accepted the validity and gave it a deeming clause. Mr. Friedland himself now, in the suit that he initiated in 2012, was attempting to claim that the registration of the charges was invalid. I ask you to turn overleaf to page 52, paragraph 13, and this is important in the context of a question that has been asked of my learned friend, Mr. Phillips, in relation to what would be the effect of Mr. Hickox re-registering the charges on the 16th of September 1997 or any date after that. And my understanding of Mr. Phillips's response to that was that he was still have been, there still would have been damage to Mr. Friedland because Mr. Hickox was enjoined forever and a day, as my Lady Arden put it, from ever relying on any charge at all in connection with his debt. Yet in paragraph 13 of the statement of claim, the amended statement of claim, it's acknowledged there. The defendant could have sought to re-register the Hickox charges at any time up to 24th October 2003 and have retained priority over the claimant's charge registered on that date. He did not do so, and any re-registration after that date would have resulted in the Hickox charges being subordinate to the claimant's charge. That pleading on behalf of the appellant in this case, I think makes it clear, answers the question more correctly that has been asked of Mr. Phillips on several occasions yesterday.
Just so I'm clear, it is more by way of an observation and a request for confirmation. We actually haven't got the Registered Land Act, but as I understand it, reading between the lines of the judgments we've got, you can be unregistered, the holder of an unregistered interest, including an unregistered charge, and the effect of registration is to give you priority. And priority is determined by the date of registration. And you are not obliged to register. You could not, there's no period within which you must register. It's just that you lose priority.
That is spot on, correct, milady. The Registered Land Act provides the registration is for the purpose of determining priority of the charge. So there can be unregistered charges, and it goes by the date, which is why the date is significant.
Yes.
And
yes. But also, the court has power. I hope I'm not cutting you short. I only want to just make a brief observation. The court has power to rectify any registration, and that would mean it could amend the date on which it appears on the register.
Absolutely, milady, and that any such action and order by the court would have to be reflected on the land register. That by order of the court, this charge is registered effective and give the date, whatever order that the court has made.
All right. It doesn't, as I had thought yesterday, alter the date on the charge. It simply alters the date of registration. So it's the same charge.
It simply alters the date. It's the same charge. It simply alters the date of the registration.
That's right. Now, just as a matter of interest, I can see that under that scheme, you can, if you like, re-register a charge. So I think you can also vary it, can't you, if you want to, and register a variation.
You can register a variation of a charge, and you can re-register, but the previous registration would have to be struck out.
Yes.
So that there are not two registrations of the same charge.
That's right. I accept that. But in this case, did the mediator ever use the word re-register?
No, he never used the word re-register. The words that he used were that Mr. Hickox is no longer restrained from registering his charges and is free to do so. And then with the caveat, subject only to the requirements of Anguilla law, and he was careful in his final paragraph to say he does not opine on Anguilla law.
So the only obligation, the contractual obligation, is around registration. We don't have to look for some process which could be carefully described as re-registration.
That is correct, Milady. There is no process, and the mediator did not speak to that at all.
Thank you.
Thank you, Milady. So I think that I have attempted to show, based on the questions that were put yesterday by my lords Burrows and Stevens in particular, in relation to the deeming date and why it was not necessary to unregister, and the impact of the court deeming a date. And it was precisely for that point of priority, because that is the important thing, and that is the value of a charge. That is the value of a charge. It was also submitted yesterday by my friend Mr. Phillips that as a matter of contract law, the registration is a breach of as a matter of contract law, the registration is a breach, and that's a private law issue. But the court, in deeming the date, was only doing so from a public law point of view. But what is the public law point of view? The public law point of view is that so that anyone looking at the register will know the priorities, and that is the greatest value of a register charge, so that anyone looking at the register can know the priorities that are in place. And so it's not simply a matter of saying, oh, it's just a public law matter, and not really going to the heart of the issue as between these parties in private law. It's also been said, submitted yesterday, that there is a continuing, any registration, I understood the submission to be that any registration of those charges, but more specifically, just dealing with it from the point of view that Mr. Hickox was permitted by the court to leave his charges as registered, but only with a new date, a new deemed date, registration date, which is the priority date, prejudices the appellant, and that he's fundamentally prejudiced because it's against the agreement that they had in clause 19 that he would not register any charge until Mr. Friedland had been paid in full. Well, it is my submission that the agreement cannot be construed to have meant that Mr. Hickox was forever prohibited from registering charges as security for the debts owed to him. And I only have to remind you, Lordships, of clause 6C to make that point. And there's also the fact that it would be inherently unfair to Mr. Hickox that he would be prevented from addressing LIR's indebtedness to him. It must not be forgotten that the debt to Friedland, the Friedland Group, was owed by HBLS and not by LIR. This was not a debt owed by LIR. This was, as Mr. Phillips took your lordships through the stock purchase agreement and the pledge agreement yesterday, this was as a result of an agreement between HBLS and others, Capjaluka partners, and the Friedland Group for the purchase of the LIR shares. So it was not, the LIR was the asset, and LIR is not the debtor. Is not the debtor. So, and the third point I would like to make is that the mediator himself recognized that the prohibition of clause 19 was finite. It was only for such period as Mr. Hickox was an insider, and that is critical. So that I hope that your lordships will not yield to the argument that there was a permanent prohibition on Mr. Hickox from registering his charges, or that the penalty was also permanent. The sanction that was issued to him was also permanent, so that he could not, having breached the agreement, he could never ever register. And I think that's so clean, so very clear from paragraph 5 of the amplification award. I should also say, the question of what is meant by prior registration in paragraph 3 of the amplification award. And again, I would reiterate that paragraph 3, and I believe that Mr. Phillips is of the same view as I am now, that paragraph 3 was simply a rehearsal of what of the mediator's findings in the final award. That was not the amplification. The amplification in my submission is contained in paragraphs 4 and 5 of the amplification award. And when you look at paragraph 4 and 5, paragraphs 4 and 5, nothing that is stated in those two paragraphs appeared in the final award. So the mediator was not very...
Ms. Morley, forgive me, Lord Sales has a question.
I'm sorry. I
think it's just a small point of clarification. I think Mr. Phillips does rely on paragraph 3 as containing the operative part of the order in the amplification award. You suggested that he didn't, but I don't think that's accurate.
Well, I withdraw that. I thought that Mr. Phillips agreed that that was the whereas, I think he called it. But nevertheless, I withdraw that, and I'll say what my position is. My position is that paragraph 3 is not intending anything new at all. There's no amplification. It is a recitation of what his finding, his final award. That's my submission.
Yes, thank you.
And so that in paragraph 3, it's just here, the mediator, I've said it already, I don't want to repeat myself. It is in paragraph 3 that when the mediator is setting the backdrop for his amplification, he says in the, and I'm starting at the third sentence from the end, it was the mediator's intent that Mr. Hickox be returned to the same status that he had as of the date of the May 6, 1996 settlement agreement. Accordingly, Mr. Hickox's status would be deemed to be that of an unregistered charge holder. I pause there to remind your lordships that in the final award, the mediator had indicated that he could pursue his remedies as an unregistered chargee if he were able to. He should take legal action to collect the indebtedness, if any, owed to him by the resort entities only as an unregistered chargee. And so he was making that clear again there, that he was deemed to be an unregistered chargee. So I don't want to go too far down the road of raising questions about the mediator's findings that there was a breach, because clause 6.6c of the, it seems to me clause 6c has dealt with the point that Mr. Hickox was an unregistered chargee and that any charge that Mr. Friedland was to get was to be subordinate to that. No, nevertheless, he was reciting that there. And then in the final sentence, he says, specifically, Mr. Hickox may not seek to rely on the prior registration of his charges for any purpose. That is in keeping with paragraph 3, where he was saying that was my intention at the time of making the final award. In paragraph 4, he expands on what exactly the change of circumstances is. Because, as I've said, in the final award, he's made only a very narrow or mild description of the change of circumstances by the bracketed words, who is not now an insider. But there was no elaboration of that. This is the elaboration or the amplification of that status in paragraph 4. And so he makes it plain that the reason why Mr. Hickox is no longer an insider is because Mr. Friedland, the collateral shares were sold to the Friedland Group and the closing took place on September 17th. Paragraph 5, further elaboration. As a result of the closing, Mr. Hickox is no longer an equity holder. Therefore, effective from that date, he was no longer prohibited from registering his charges. And then accordingly now is him making it plain the situation as it stands now. It, in fact, is a situation as it stood then, but that he is actually just plainly stating it now in this document. Because as your lordships might appreciate in terms of the chronology, Mr. Hickox, Mr. Friedland bought the shares in September 1997. It is then that I'm saying it is then that he appears to have discovered that Hickox had registered the charges in January of that year. He raised the dispute. The dispute was resolved by the mediator in the final award. Mr. Friedland got his deficiency judgment in June of 1998. He got his deficiency judgment in June of 1998, and then comes back to the mediator weeks after. My submission is that Mr. Friedland did not appreciate, and this is not an original thought because it has been stated in judgments of the courts below in Anguilla. Mr. Friedland did not appreciate that in acquiring LIR, he acquired its liabilities as well, including the registered charges. And so when he got his deficiency judgment against LIR and others, he's now confounded by the prospect of priorities. And he wanted to remove and rid the register for the property that LIR owned from these charges. That is an interpretation, whatever the interpretation that the parties had, they came back to the mediator weeks after Mr. Friedland had got his deficiency judgment. And as I've said before, Mr. Friedland never sued in his own capacity to say that he had been wronged by Mr. Hickox until 2012. And therefore, at this point in time, my submission is that the mediator's focal point here in this amplification is a recognition that Hickox was no longer restrained from registering his charges and was free to do so, subject to Anguilla law requirements. And we have it that Anguilla law did not require him to re-register. Anguilla law dealt with the situation knowing all of the facts and the mediator's findings and deemed the effective date of the charges to be the 16th of September.
If the court had said, no, we're not going to amend the date, and you have to get Mr. Hickox to withdraw his registration of January 1997, how would the court have gone about that?
I'd be surprised if the court, given that the court accepted the mediator's finding that there was a breach of the settlement agreement by the registration in January, I'd be surprised that the court would decline to give relief. The court, in fact, gave relief by deeming the date of 16th of September 1997 to be the date. That is a relief that the court gave to, in that case, LIR, who was the party to the action. And again, I have not, I know that there have been many questions put to my learned friend regarding the submission, repeated submission that the prohibition of clause 19, and in fact, the sanction of the mediator was to be forever. He could at no point in time re-register. But it's I think is very difficult to interpret the amplification award in that way. And I hope my submissions that I've made already has adequately addressed that. Now, having looked at the High Court, how the High Court addressed the matter of the registration of the charges in face of in the context of a breach of the settlement agreement, the first time that Mr. Hickox attempted, Mr. Friedland attempted to take any action in connection with the registration or the intended auction was by way of his application in the U.S. bankruptcy court to reopen the bankruptcy proceedings against HBLS and to get relief there. In fact, specifically an injunction to restrain Charles Hickox from holding the auction on the 2nd of May 2012. And the U.S. bankruptcy court judgment is at page 301. And at page 30, the give a background, the background to the bankruptcy. And then at page 305, in setting out 304 to 305, it sets out the Anguilla litigation regarding the charges and underlying loans. And on page 305, the judge there records the fact that the court considered the third charge, that's the High Court, the first instance judgment, held that the charge was effective only from the stock sale date, after which Hickox was no longer an equity holder in LIR. And that last sentence of that first paragraph on page 305, he says, as such, the court found that the mediator's amplification only delayed the effective date of the third charge to the stock sale date, and that under Anguillian law, there was no need for Hickox to refile that charge. Over on page 306, on the last sentence of the first paragraph there, thus, after years of litigation on issues relevant to the motion, Anguillian courts have, based on the mediator's amplification, given effect to the charges as of the stock sale date and have not required Hickox to refile the charges. So I'm pointing your lordships to this for the reason that it shows the commonality of the reasoning of various tribunals. And the main importance of looking at Justice Lifland's judgment here is that the settlement agreement and indeed the mediator's awards pursuant to any dispute raised under the settlement agreement is governed by New York law. I don't believe it's any different from the law we're applying. We're the same principles, but here we have a New York judge who is making these assessments of the case and having it same understanding and interpretation of the amplification award as have the Anguillian courts. And in paragraph on page 308, he begins to set out and discuss the merits of the underlying claim. The important one for the purpose of our appeal before your lordships here today is on page 309. where he gives the second point that Mr. Friedland asserts that Hickox is in violation of the mediator's finding that Hickox may not rely on the charges for any purpose. And I'm citing this in light of my Lord Sale's questions yesterday in relation to perhaps by deeming it so, the Anguilla court have given Mr. Hickox a purpose. He given him an option of relying on it for a purpose. But here, this is a judgment which predates our hearing here. And we have Justice Friedland in this case saying this assertion is meritless because the mediator also found that as of the stock sale date, Hickox was free to re-register the charges, subject only to the requirements of Anguillian law. See amplification of mediator's prior award. And Anguillian court subsequently gave effect to the charges as of the stock sale date without requiring their re-registration. Specifically, the Eastern Caribbean Supreme Court deemed the third charge effective as of the stock sale date, and the Anguilla Court of Appeals validated the other two charges. The Court of Appeals also declined to consider the Eastern Caribbean Supreme Court's treatment of the effective date of the third charge. Each of these courts also accounted for and applied the mediator's determinations in their decisions. Friedland's contention is therefore certain to fail, as the mediator held that the charges could be re-registered under Anguillian law and Anguillian courts, with due consideration of the mediator's findings, have permitted the charges without requiring their re-registration. And therefore, an overleaf, Mr. Justice Friedland, using an American football analogy, says to grant the motion, he would be permitting Friedland an end run around some of the sound findings of the Anguillian court. Of course, this is not binding at all on your lordships, and in fact, I wouldn't even go so far as to say it is persuasive, but I use it to demonstrate that the New York position, understanding and interpretation is consistent with the one that we have been advancing to your lordships.
Isn't that rather more significant than you have suggested? Because the mediator's award was surely governed by New York law, and here we're seeing that Judge Friedland, a judge of the Bankruptcy Court of the Southern District of New York, the court which after all controlled the mediator, that Friedland's contention was certain to fail.
I may have that view, my lady, but I would not want to put it as I'm sure that this court will treat with it as it deserves, gives it the weight that it deserves. But certainly the fact that the agreement and the mediator was subject to New York law. In fact, the mediator was, as my lady Arden points out, appointed by Justice Friedland, and therefore, and as we know, he dealt with the matter from start to finish. So he was completely familiar with all of the material facts and so on. So that, my lady, we consider to be indeed relevant, that by his interpretation, the mediator's amplification award did not require a permanent prohibition of Mr. Hickox from registering his charges, or even that they must have been formally going through the process of filing documents to re-register them, because it was, after all, subject to Anguillian law requirements, which have been stated by two courts.
Sorry, Ms. Small-Davis,
Yes,
perhaps you could assist me at the top of page 310. And I asked this question yesterday. I want to get it firmly in my mind. At the time that the counterclaim was lodged by LIR, was Friedland in control of LIR?
At the time that the counterclaim was filed, my lord?
Yes.
Yes. At the time that the counterclaim was filed by LIR, Friedland was in charge of LIR, was in control of LIR. He continued to, he only changed ownership and control of LIR changed in, I believe, April 2008, which was a date after the trial had been completed, but before judgment, just shortly before judgment was delivered.
And
So
also,
he was in control.
yeah, as a matter of Anguillan law, would Friedland, in his personal capacity, have been able to join in those proceedings if he so wished?
Millard, he would have been, he could consider himself a necessary party and filed, it wouldn't be interpleader, that's not the correct term, but he could apply to be joined as a party for the purpose of the counterclaim, because that was, the debt was actually due to him, and it is he who really was the one sustaining the loss. And apart from that, even if he did not join in this specific suit, he could have filed his own at that juncture.
Thank you very much indeed. Thank you.
I feel in a very, very strange and position to which I'm not accustomed. And that is that I believe I've made all the points that I think I need to make in a very short time. That is quite unlike me, I must say. I don't know whether there are any other questions. I could go through, I had some points on the appellant's case, to deal with the appellant's case, but in all honesty, I believe that I have addressed them in the course of the submissions I've made so far. And I really would like to revel in this feeling that I've completed my submissions in under the time in which I've given myself to do.
Very good. Very good. Thank you, Ms. Small-Davies. I don't think there are any questions for you at this stage. So we'll move on. Oh, my Lord Burrows has a question.
Yes, my lord.
Yes, could I just take you back to the electronic page 254, and it's paragraph 118 of
Yes, my lord.
the first instance decision. As I understand it, the case being put against you is that we are required to interpret what the court was there saying as if that's all a matter of validity of the charge. It says nothing about whether or not Hickox is allowed to rely on that charge. In other words, it's saying nothing about whether Hickox will be in breach of contract. Now, wouldn't it be fair to say, in support of your case, that it would be somewhat peculiar for a court charged with all the information it's got, making the statement in paragraph 118, thus any registration by Mr. Hickox of the third charge ought only to be effective, etc., if they are effectively saying, but of course you'll be in breach of contract if you rely on that charge, so that to that extent, we're happy for you to be in breach of contract. That would be a pretty alarming statement, wouldn't it, if that's the correct interpretation?
It most certainly would, my Lord Boris. And I think that, in fact, that sentence was the Anguillan court joining with and supporting the mediator's sanction that Mr. Hickox could not rely on any prior registration. And that was a sanction. He couldn't rely on a prior registration. That is a registration effected during the period when he was prohibited from doing so. That could be the only sensible way to interpret prior registration. And in fact, if the court knows, the other baffling point, I must confess, is the idea that he would be entitled to register the charges, but he would not be entitled to rely on them at all. Then what would be the point? There'd be absolutely no point. It'd be the court acting in vain. What would be the point of recording on a land register, several land registers, that these charges are registered effective the 16th of September. However, the charges are meaningless. They stand for nothing because the chargee cannot rely on them for any purpose. That is a totally and completely meaningless exercise, which I doubt any court at all would ever encourage or endorse.
Thank you.
Lady Arden?
Yes, I wondered if this dovetailed the point about what sort of registration system there exists in Anguilla. It's not a case where a charge is void if it's not registered. It's the,
No.
Sorry, I did say no and I interrupted, pardon me. It's not that sort of system. It's a system which says if you register, you get priority. So validity is not a point. If that's not covered by registration, that's a matter of the general law.
That is correct, and thank you for that, my lady. That is correct. The registration is a matter of law, and whether it's registered or not, it would remain valid. And in fact, the mediator recognized that by saying that he had powers and rights as an unregistered chargee, and if he could, as an unregistered chargee, foreclose under Anguilla law, then he was free to do so. The mediator recognized that in his final award. So that the idea that he could be permitted to register, but he could not rely on them for any purpose, I think, with all due respect, my lady, is not the sensible way of interpreting the law.
So would that be part of your answer to Lord Burrows?
Certainly, my lady, it would be.
It's just that we're more familiar with a different system of registration, so we're having to switch into the Anguillan one.
Yes, and if it helps, we can send along the Registered Land Act or its relevant sections. I think it's section 64 through to 74, if that helps.
I think, really, Davis, that would be very helpful if we could be supplied with that.
Could I also ask for the section which deals with priority and the section which deals with rectification?
Most definitely, certainly, my lady.
Thank you. Unless there are any further questions for Ms. Small-Davies? Thank you very much. Mr. Phillips.
Lord, yes. Well, can I compliment Ms. Small-Davies on achieving what I miserably failed to do, which is not only to be succinct, but to come in significantly below her time estimate. So hats off there. I don't, however, agree with all of her submissions. I'm plainly not going to reiterate what I explained to you yesterday and the answers I gave to the questions. I'm going to deal with a number of specific points. But I respectfully agree with what my Lord Sale said in the course of submissions to Ms. Small-Davies. The analysis he put forward, or his understanding of my analysis of paragraph 3 of the amplification award, is correct. It does contain a recital. It says what the mediator had done in the final award, but then in the last sentences, it expresses in the present tense the argument I've already advanced for all purposes, that the prohibition continues. What I need to clarify from a misunderstanding of Ms. Small-Davies is that it is not our case that the prohibition, which we do say is permanent, is a permanent prohibition against registration of charges. It's clear, we say, by implication from the final award, but in any event, explicit in paragraph 5 of the amplification award, that Mr. Hickox had the power, the right, to register charges after the 17th of September 1997. Where the permanent prohibition bites is that he is permanently prohibited from taking advantage of, relying on charges which he registered before that date in breach of contract, because, as the mediator said in the amplification award, his intention was to restore Mr. Hickox to the position which he'd had at the date of the settlement agreement, which was as an unsecured creditor. And that therefore, going back to what I said yesterday, without for a moment reiterating it in its detail, is the distinction which we draw between the award of the Anguillan court and the private contract. My lady, yes, I'm sorry.
Just hoisting in that this system of registration is about priority.
Yes.
Why isn't it not enough that the registration occurs after the 19th of September? What else could the mediator have been trying to achieve? That's all that's achieved by registration is priority date. And if the priority date is shifted after the date of the stock sale, why was that not achieving what the mediator had in mind?
But I'm sorry.
No, sorry. I wanted to get away from had in mind. He had expressed.
Right. As I understand the question, the answer is that the mediator permitted registration after the stock sale date, 17th of September 1997. And if that had happened, then the registration would have been affected and permitted by the mediator. But the analysis of the contract, which I have put forward, and which I'll come to Ms. Small-Davis's in a moment, because to a substantial extent she agrees with me, is that he is prohibited from relying on registrations which took place before the stock sale date, but is permitted to register and rely on the registration after that date.
Yes, but if the effective date of the registration is after the 16th of September, when he had ceased to be a resort entity, what difference does it make to whether you actually have the effective date ordered by the order of the court, or the effective date because he turns up at the registration office with a second copy of the charge?
I understand that question, and if the Anguillan court had made an order which was binding on Mr. Friedland, and I'm going to come to this in a moment because he wasn't a party to it, to that order. Lear is a separate legal entity. Issue estoppel doesn't arise, is the first point, but I'm going to develop it in a moment. And the second point is, what we haven't done is to trace through what the Anguillan courts ordered. We have looked, and I failed miserably yesterday to take you through it in detail because I hadn't prepared it, because I didn't see it as an issue in this appeal, because it's not something which the Court of Appeal relied on in its reasoning, in its judgment, and it's not something which the master relied on in his reasoning, in his judgment. So it emerged, I think, from Lord Stevens or Lord Burrows as a question to me yesterday. And although, of course, I have looked at and read the judgments before yesterday, I hadn't focused on the specific questions which I was being asked. So the answer to my lady's question is this: if there is an Anguillan court order which binds Mr. Friedland, saying that Mr. Hickox's charges are deemed to be registered at a date after the stock sale agreement, then that would have the effect which it plainly says. And what we say is, first of all, it wasn't an order to which Mr. Friedland was a party. So, and I'll come to this in a moment, but in summary, it takes effect in public law, but it doesn't define the contractual rights which arise under the 6th of May settlement agreement. And secondly, when we look at what was actually done, there is a factual, it seems to me, and it's certainly my submission, there's a factual bewilderment as to where the first instance court and the Court of Appeal decisions end up. It will be my submission that, as so often happens, that the preliminary issue which was defined in this case with the intention of resolving these effectively liability may well not have done so at all because of the undecided, undetermined facts which have now been thrown up, and I'll take you to them. And it will be my submission that if you agree with my construction of the private law position, then the only proper and fair course is to remit the action to Anguilla to unpick the factual uncertainties.
Okay,
but
you'll want to develop these, but while I still have the mute button off, could I just put a point on the table? If the court makes an order altering a public record, as it did here, to alter the date of registration of the charge, that is an order in rem, and it bound Mr. Friedland as it would bind any other creditor of LIF.
Yes, I understand your point, and let me deal with it now. Then I was coming to it later, but let me try and deal with it now. The practical effect of the order would be that if a third party registered a charge after Mr. Hickox had registered his charge, then that third party's charge would rank after Mr. Hickox's charge because of the in rem public order which was made. So far as Mr. Friedland is concerned, there is an in rem determination by the court of the date of the deemed registration. However, because of the contractual provisions which the parties have entered into, notwithstanding the fact that the court has said the charge is registered at a certain date, and so it is a valid registered charge, contractually, Mr. Hickox is prevented from acting in that way without placing himself in breach of contract. And my lady is absolutely right, if I may say so with respect, in that it did confer the rights on Mr. Hickox to rely on the charges, subject to what I'm going to say in a moment. But by relying on them, he put himself in breach of a private law right, a private contract, where he had agreed not to do that. And so notwithstanding the fact that the reliance on the charges, the sale, no doubt the passage of good title to the purchaser, and all the other conventional aspects of a property transaction have taken place, that begs the question whether by acting in that way, Mr. Hickox has made himself liable personally to Mr. Friedland for breach of contract. And if I go back to what I said to my Lord Burrows yesterday, if a person has a first charge over a property and as part of a commercial transaction agrees with somebody else that he won't enforce it, but then does so, then he will be liable in contract. So that's the answer to that question. Subject only to this, that when I take you to what the courts did in Anguilla, it is extremely confusing to try and work out what exactly they ended up with. Because, well, I won't spoil the surprise. I'll take you to it when I get there. Can I then just before going to the Anguillan decisions, and this is one of the only, I think it may be the only other point I need to say which is truly in reply, apart from the Anguillan submissions to my learned friend Miss Small-Davis. But she, in her submissions, she said that she agreed with me, or I agreed with her, that paragraph 3 of the amplification award was not anything new at all. It was a recital of the final award. And that has very much been my submission, because the final award contains what the Court of Appeal has described as a clear prohibition. And my submission is that paragraph 3 has, in the recital, set out what was done in the final award, and then has said that continues. And that, from what Miss Small-Davis says, is not in dispute between us. She proceeded to rely on paragraph 5 of the amplification award, and I've made my submissions on the proper construction of that already, and namely that it's dealing with registration, not an ability to rely. And my understanding of Miss Small-Davis's submissions is that she too sees it as dealing with registration, and her case, and this seems in my submission to be becoming the real issue in this appeal, her case is that because Mr. Hickox was free after the stock sale date to register his charges, and because of the deeming effect of the Anguillan decisions, he did in fact, as a matter of in rem public law in Anguilla, have the charges registered and therefore was entitled to rely on them. So the dispute over the semantic terminological meaning of the arbitration award, on which I focused a lot yesterday, appears in my submission to have slipped away. And what is really now the question is whether the Anguillan court has validated the otherwise in breach of contract valid registration of the charges. And in order to answer that, and I accept as a proposition, of course I accept that if the Anguillan charges in personam has allowed Mr. Hickox to do what he did, then there's no breach of contract. I accept that. The question is whether it did it. And in my submission, it didn't really for a number of reasons. But the principal reason is I do say that it was an in rem decision, which doesn't. And when we look at the judgments in a moment, you'll see why I say this. Doesn't address the private law issue which we're concerned with in this court. And then there is what in my submission is an unfortunate lack of clarity as to what actually happened factually. But rather than saying that in abstract, I'll take you to it. The judgment at first instance is at page 182 of Mrs. Justice George Creaky, as indeed she then was.
Could I just ask you, because
Yes.
before you go to the judgment, are you saying that the mediator's final award or the amplification award could create a breach of contract if it was not already a breach of the settlement agreement?
Well, I say that it already was a breach of the settlement agreement, but I say that the mediator's final award and the arbitration amplification award could create further breaches. And the jurisprudential reason for that is in the contract which the parties agreed, they conferred on the mediator very generous jurisdiction. He wasn't entitled to rewrite the contract, but he was entitled to interpret it and clarify it and define it. His decision was final and binding on the parties. So if on application of one party, he said that pursuant to what you've agreed, you cannot do this, then that flows back to the original consensual agreement. And I suppose that the proper answer is it doesn't change what is agreed in the settlement agreement, but what it does is to clarify it in a way which is binding on the parties.
Thank you.
I suppose, my lady, it's equivalent of a court judgment. If you apply it to the court to restrain someone from committing a breach of contract, if the court declines to give an interlocutory injunction or an interim injunction, as they now are, an interim injunction, but nevertheless defines the contract in its judgment, there will then be clarity as to what the contract meant. So I was going to go to this judgment, and the sensible place to start is on page 182, which has the title page. And the importance of that is simply to demonstrate that Mr. Friedland was not a party to this litigation. It is correct that up until the 9th of April 2008, and I'm grateful to modern technology and my junior, Miss Lee, who sent me a message to give me the date, the 9th of April 2008, Mr. Friedland had an equity interest in Lear, but that doesn't make him a party to the agreement. As Miss Small-Davis has rightly said, and as I think I said yesterday, he sold that interest before the judgment was delivered. So the claim was by Mr. Hickox against a legal individual who was not Mr. Friedland. He wasn't a party to the litigation, and what I've accepted, and I do accept, is that he, as will any other member of the public, be bound by the in rem ruling. So a subsequent charge holder, which was registered after Mr. Hickox's deemed date, would rank after him, but he's not bound by the private rulings because he wasn't a party to the litigation. And in any event, on an application of the principles, I will say that when you look at the way the courts dealt with the issues, it is far from clear that they dealt with the issue which we are focusing on in this appeal, but a broader issue.
Lord
I'm
Stevens.
sorry, Mr. Phillips. Sorry, and I can't resist asking the question. I'm sure there's going to be no sensible answer to it. But is there any sensible reason why he did not join in these proceedings? Known.
There was no need for him to have done so. He wasn't seeking to. Mr. Friedland was not seeking in these proceedings to enforce any personal rights. What he was doing, what Lear was doing, was just to set the historical scene, as I'm sure my lord knows. But what had happened was, at a time when he was in control of the construction and development of this resort, Mr. Hickox invested very large sums of money by way of loans to the company. Those monies were acknowledged in the form of promissory notes, and they're referred to in the judgment as the first transaction, the second transaction. And the sums due under the promissory notes were secured by two charges, the first charge and the second charge. And the issue in the litigation had nothing to do with Mr. Friedland personally, although he was the equity owner, and so the judgment would have impacted on his wallet and what was in it. The issues in this litigation were Mr. Hickox seeking judgment on the promissory notes, and Lear, successfully at first instance, challenging the validity of the transactions for a series of conventional arguments, breach of fiduciary duty, self-dealing, want of authority, and the construction of the pledge agreement, because the pledge agreement, the judge found, although the Court of Appeal disagreed, had the effect of removing the voting rights from the transferees if they were in default, which Mr. Hickox was for most of the time. So there was a good reason. That may not, I thought for a moment, when you said there may not be a sensible answer, having heard me say things yesterday, you thought there was little point in asking this advocate a question at all, which I was...
It wasn't that at all. Thank you very much.
So I've made the issue a stopple point, and whether Mr. Friedland is affected by this, insofar as it concerns his private rights, and I will support that by saying that the way it was dealt with in the judgments simply is not a proper consideration of the issues which we have advanced in this appeal on the proper construction of the settlement agreement, and in particular the amplification award. The charges were dealt with at first instance very lightly indeed. They did not attract detailed judicial attention, but they attracted significantly more judicial attention than they attracted in the Court of Appeal, as you will see in a moment. So moving from page 182, which is the first page, to page 191, this is in her summary of the facts. And the judge says at paragraph 22 at the foot of the page, on the 31st of December 1996, CJP paid the Friedland Group the first installment of $1 million. On the 9th of January 1997, Mr. Hickox registered three charges. That's the money due under the mediator's settlement agreement. On the 9th of January 1997, Mr. Hickox registered three charges against Lear's leasehold interest in respect of the various sums claimed by him, which gave Mr. Hickox priority over the sums due from the partnership to the Friedland Group. Mr. Hickox, therefore, felt secure to default on the remaining payments. That's the sums due under the 1996 settlement agreement. The installment of $1 million due on the 28th of February was never paid. On the 6th of March, the mediator declared a default in the performance of the settlement agreement, and then he reported the default. So that sets out the judge's understanding of the circumstances in which the charge was registered in 1997.
The paragraph again, Mr. Phillips?
It's subparagraph 22, my lord, on page 191.
Thank you very much.
It's the one at the bottom of the page. So it's paragraph 7, subparagraph 22.
Thank you.
Then she, over the next page, 192, she deals with the issues which she has to deal with. At the opening of the trial, counsel on both sides agreed the issues. The determination of some issues may no doubt have the effect of causing others to fall away. In this regard, I agree with Mr. Henriquez, learned Queen's Counsel, and Mr. Hickox, that the logical order for considering and determining the issues is as set out in his closing submissions, which order I generally adopt. At the same time, having regard to the detailed approach which I had advocated, in hope of marrying them both, I have captured all of the essential issues raised in this case. And then she summarizes them. And you'll see A, B, C, D, E, and F. And F is the charges. And the fact that it's the last of the issues is not in itself significant, but it is the final issue which she deals with. F, whether Lear is entitled to have the registration of the charges set aside. And that's on internal page 12 of the judgment. And we don't come across any consideration of the issues of the charges or of the settlement agreement until we get to internal page 72, which is page 253 of the bundle, which is the page which my learned friend rightly took you to. This is the only judicial consideration which she gave in relation to the charges. And it's 2 paragraphs. And the first paragraph is this. Lear seeks an order setting aside the registration of the 3 charges. The first and second charges are pursuant to the first and second transactions. That's the 2 promissory notes which backed up Mr. Hickox's loans, which I have found to be unauthorized and therefore void. Consequently, the security, namely the first and second charges, are also void and of no effect. The third charge is security for the standby loan agreement in respect of the Barclays construction loan. The standby loan agreement, though mentioned in these proceedings, is not the subject of these proceedings. So she identifies the three charges. And the consideration of the matters which we've been dealing with in this appeal is contained in paragraph 118. And you will see she starts by saying that counsel for Lear relies on the provisions of clause 19 of the settlement agreement, which she summarizes, and then continues, it is not disputed that at the time when monies were owing to the Friedland Group, pursuant to the settlement agreement, which were also secured by a pledge of the Lear shares, that Mr. Hickox in January 1997 procured the registration of the 3 charges. I've already alluded to Mr. Hickox's strenuous protestations of not being a party to the settlement agreement and the confirmation of the New York Court of the Mediator's Award, in which Mr. Hickox was held to be so bound. Further, I've earlier ruled that Mr. Hickox, having sought to take and enforce the benefit of its terms, must be deemed to be bound also by the burdens. And then she refers to the final award by order of the New York Bankruptcy Court confirming the final award, in which he found that the registered charges in favor of Mr. Hickox on Lear's interest after the settlement agreement was executed by the parties constituted a violation of the terms, spirit, and intent of the settlement agreement, including but not limited to paragraph 19 of the settlement agreement. So if I pause there for a moment before continuing with the remainder of this paragraph, she has not addressed at any stage the sanction. She hasn't looked at the final award. She hasn't looked at the amplification award in the context of the issue which we're considering in this appeal. She's not looking at whether, as a matter of private contract law, because Friedland wasn't a party to the proceedings, it wasn't an issue in this case. She's not looking at whether the private contractual provision gave rise, well, first of all, prevented Mr. Hickox from relying on the registration of the charges. And secondly, she's not looking ahead to see that if he did so, whether he'd be in breach of contract, which sounded in damages, which is the issue in this case. So at the moment, unless it changes in the next few lines, not only is Mr. Friedland not a party to this litigation, But the issues being determined by the judge are not the issues in this action. So moving on then, at the last 3 lines, it's common ground that Mr. Friedland reacquired the Lear shares by auction after the payments under the settlement agreement were not met. It is only at that time that the terms of the settlement agreement may be said to have, to some extent, become spent. And that phrase was seized on by Mr. Hickox in the early stages of this litigation, where he argued that the settlement agreement had become spent, which the courts below rightly, well, the master said he thought it had become spent, but the Court of Appeal, in a preliminary, one of the preliminary issues which hasn't been appealed, said it hadn't become spent. Thus, any registration by Mr. Hickox of the 3rd charge ought only to be effective as from the date of the sale of the Lear shares under the settlement agreement. Accordingly, I would order and direct that the registration of the 1st and 2nd charges be set aside, and the registration of the 3rd charge be deemed to be effective only as from the date following the sale to Mr. Friedland of the Lear shares pursuant to the settlement agreement. She made that direction in relation to the 3rd charge, notwithstanding the fact that the 3rd charge hadn't actually featured as an issue in the action, as you see at the conclusion of paragraph 117. But be it as it may, she made that decision in her judgment, and it was embodied in the court order.
But you're, sorry.
I'm sorry, my lady.
No, please finish the point.
Well, it was embodied in the order, but I'm going to take you to the terms of the order in a moment. So I'll gladly answer your question.
It's just that your submission was that the judge was not looking at the private contractual provisions, but she specifically referred to the settlement agreement.
Yes.
And she's looking also at the sanction imposed for breach of the settlement agreement. So
well, I don't see that she addresses the prohibition contained in the final award or the 3rd paragraph of the amplification award, but it may be I've missed it. Which passage does my lady have in mind?
Well, you've got the final award specifically referred to and quoted, the material part quoted. The sanction is there at the end of the preceding paragraph before we start the unnumbered paragraph. And then it carries on, it's common ground. Mr. Friedland reacquired the Lear shares by auction, etc. It is only at that time that the terms of the settlement agreement, which must be her view of the terms of the settlement agreement as informed by the final award, may be said to some extent to have become spent. Thus, any registration ought to be only effective from the date of the sale of the Lear shares under the settlement agreement. That's yes. So she's quite clearly looking at the contractual provision.
Well, can I deal with both points? I mean, first of all, you're plainly right. She is dealing with she's looking at the contractual provisions. But what I was saying was, and I'll make this clearer. What I was saying is she wasn't addressing the sanction, the prohibition from relying on the registration in both the final award and the amplification award. What she is dealing with in the passage which you've directed my attention to, which is the quotation in italics, is having decided that Mr. Hickox was bound by the settlement agreement, which he had strenuously denied, she's deciding whether or not he was in breach of it. And so when she goes on to say, it is only at the time that the terms of the settlement agreement may be said to have, to some extent, become spent, what she's addressing is the fact that after the sale of the shares, Mr. Hickox was free to register his charge. And so what I am doing is, I hope, making clear that she is focusing on, first of all, was Mr. Hickox a party to the settlement agreement and therefore bound by it? Secondly, was he in breach of it? She doesn't at any stage address the question whether he is entitled as a matter of contract law to act in reliance on the charges without placing himself in breach of contract. As a matter of public law, I accept he is. He's got a validly registered charge because of what she did. But that begs the question, which in my submission is the central issue in this appeal, is whether exercising his rights in relation to the registered charge places him in breach of contract. And that's why I say she wasn't addressing that issue, because it wasn't an issue in the case, because Friedland wasn't a party to it, and because it simply, as you've seen, I've taken you, I think, to every reference in the judgment to the charges. It simply isn't something which was before her, and therefore she didn't address it. So my case is, I'm sorry to interrupt you, but just I'm anxious to make sure that, right or wrong, at least I've made clear what I'm saying. I am saying yes, as a matter of public law, the charges were registered, but that begs the question whether exercising the right conferred by registration placed him in breach of contract, which sounds in damages, which is the way the amended claim in this case is put.
So if she had addressed that, what would she have to have said in the terms of this order? If she considered and that there was a prohibition of a permanent nature on reliance, that would have made a fundamental difference to this order. She would have cancelled the third charge.
Well, the third charge, this is one of the very strange, there's a number of strange features in these judgments, but the one here is that this third charge arose under the standby loan agreement, which wasn't an issue in the case. And I don't know what she would have done, but what I do know, and what I submit is very important when looking at the principles of issue estoppel, is that this simply was not an issue which was before her. The question of whether acting in reliance on the valid charge would place Hickox in breach of contract was not an issue before her. And it wasn't an issue before her because Mr. Friedland was not a party to the claim, and because that was never considered at any stage by anybody in the proceedings.
Well, that would be
I'm sorry.
I just said that would be an argument for saying that Mr. Friedland should have come along and sought to appeal this as an interested party, or at least to get some kind of clarification that it didn't cover the point you have in mind. You have stipulated.
Well, it's not a Henderson type of case in my submission. The principles of Henderson are reasonably generous. And although we all encourage everybody to bring all the claims in the same set of proceedings, Mr. Friedland was a stranger to this litigation. Lear, a company in which he had an equity interest, was the party. Nobody at this stage was looking at the issue which we're looking at now, because what had happened was that Lear, relying on promissory notes, Hickox, relying on promissory notes, was seeking to recover what he said was a debt, and Lear was defending that claim and seeking by counterclaim to set aside the charges over its interest. So you only have to look at what the issues, and if we go back to Mr. Henriquez's list of issues, if you look at the issues which the judge decided arose in the case, which is on page 193, you'll see it's all concerned with corporate governance, the validity of the transactions, and also a slightly odd claim to contractual costs. The reason the charges featured at all was because it is said that the transactions under which they were created were void. Nobody was looking at liability for breach of the settlement agreement. my lord.
Well, I understand your submission to be that the issues in this litigation are different from the present issues before us. And I see that in the context that the same legal team were representing LIR, and LIR was under the control of Mr. Friedland. One of the issues in this litigation is whether the charges are deemed to be effective as from the 17th September 1997. And if so, whether therefore there is no breach of contract. That must have loomed large in Mr. Friedland's mind at the time. And the finding at paragraph 118 must have rung alarm bells with him, because it certainly does affect his personal interests, potentially, as to breach of contract.
I can only say, my lord, that the expectation that it would have loomed large in his mind, if it was right, it was never anything which, speaking as one of the lawyers in the case, we were aware of. We in the case, this case where we're looking at the judge's judgment now, we were looking at the issues which the judges recited as the ones she had to decide. There was no consideration of contractual liability, potential contractual liability for Mr. Hickox if he relied on the charges. It simply was not part of the litigation. And I'm not giving evidence. I'm not telling you now that I remember it 12 years ago, because of course a lot of water has passed under a lot of bridges. But what I can tell you is, if you look at the judgment, the only consideration given of the question of the registration of the charges is in paragraphs 117 and 118, which I've taken you to. And I hope I've made clear in my response to Lady Arden that what the judge was considering was whether Mr. Hickox was a party to and bound by the settlement agreement, and whether he was in breach of it. The breach of it. There was no further consideration as to whether, if relying on her deemed registration date, he then sought to enforce the standby loaner charge, which was the only one which was left standing, that would put him in breach of contract. Just wasn't there, and she hasn't addressed it. And at one stage, when we were preparing this case, we considered whether we should be putting in authorities on issue estoppel, but because it didn't feature in the Court of Appeal's judgment, and I didn't see this as becoming the point which it has now become over the last 2 days, we haven't put in any of the authorities on which we would otherwise have done, which you'd have been able to see. But if after this you look at them, you will see in my submission there's a Virgin, Lord Sumption gave judgment in the Virgin Atlantic case about eight years ago, which I'm sure the board will be familiar with, in which he described issue estoppel as not a rigid tool, but one had to look at what was really decided and what was not decided. And that's plainly that's not even a head note, it's just a summary. But the point is, Mr. Friedland was not a party to this litigation, and secondly, the judge doesn't address the issues. And I want now to go to where I was, if I may, after addressing Lady Arden's concerns, to invite you to look at paragraph 5 and 6, because these are the operative paragraphs of her judgment, and the order which was eventually drawn up is in the same terms. Paragraph 5, you can scan it, simply sets aside the first and second charges. And then paragraph 6 says the registration of the third charge is hereby deemed to be effectively registered only as from the date following the sale of the Lear shares pursuant to the settlement agreement, namely as from the 16th of September 1997. And you know my submission that this is, in notwithstanding the res judicata point, this gives rise to an in rem position and doesn't address the private contractual position. But where we go from, where we are at this stage is the first two of Mr. Hickox's three charges have been set aside, and the wording is the registration of the first and second charges is hereby set aside. The matter came to the Court of Appeal later, a year later, on the 23rd of March 2009, and the judgment begins on page 256. Inevitably, well, not inevitably, but not surprisingly, the parties are the same. It's the company and Mr. Hickox. Mr. Friedland is not a party, and by this stage, he's not an equity, has no equity interest as well. The Court of Appeal dealt with the issues of the charges on page, well, in fact, my number is 0, but I think it's a typing error. It should be 288 in subparagraph 6 of paragraph 93. And if my lords and lady have that, you'll see that it reads grounds 3-30 and to 3-32 question the learned judge's findings and conclusions relating to the first, second, and third charges. These grounds were not pursued at the hearing, and no skeleton arguments addressed them. I have concluded, therefore, that they were abandoned. And that's the entirety of the Court of Appeal decision on the charges. The rather strange consequence, well, not strange, but I think unexpected when this matter arose yesterday, is the form of order which was produced as a result of that. The appeals having been deemed to be abandoned, the judge's orders in relation to the charges were left untouched. And you see that on page 299 in paragraph 122, where the outcome of the appeal is that Lear's appeal is to be allowed to an extent, and the cross appeal is allowed. And the paragraphs numbers of the judge of the award, the order which are set aside are 3, 4, and 7, and 1, 3, 4, and 7. And if you then go back, although you'll remember it, I'm sure, if you go back to the order made by the judge on page 254, you will see that the practical effect of that is that the registration of Mr. Hickox's first two charges remains set aside. And that, when one looks at the office copy entries between pages 154 and 178 and following, which are dated, were obtained between 2011 and 2012, hasn't been reflected in the register. Nor does it seem that Mr. Hickox recognized that his first two charges had been set aside, because it seems to be common ground that he relied on three charges for the purposes of selling the leasehold interest in Lear. And I confess, I've thought about this since I read the judgments properly, and I don't have an easy answer to where that leaves the board in this appeal, because two of the three charges, from my reading of the Court of Appeal and looking at the Court of Appeal order, have been set aside. And we've all been proceeding. I think when I was first asked the question by Lord Burrows yesterday, we've all been proceeding, and it's in the pleadings, that Mr. Hickox relied on all three charges for the purposes of enforcing his security. And it seems to me, and it's certainly my submission, that the facts are simply not clear, and I don't think any sensible inquiry is going to enable the board to be in a more secure position than it is at the moment.
Well, why does it matter at this point? Because the third charge secured a quite considerable sum of money. Is it being said that there would have been no deficiency?
I don't know, because I'm not. This is where the facts, a proper factual inquiry would see how much was realised on the sale. Look at what the enforceable liability was.
Mm-hmm.
At the moment, I just don't know. I don't know whether there'd be a deficiency. Mr. Hickox recovered in excess of $50 million on the sale of the property.
But surely that's the case for an account of the proceeds of sale. It's nothing to do with this action.
Well, it is a factual conundrum as I see it. I agree with my lady. It doesn't undermine my core submission that if there is a breach of contract, there should be damages for breach of contract. My lord.
Yes, Mr. Phillips. I'm slightly mystified by this point. I can see that when one traces through what has happened in the Court of Appeal, the first Court of Appeal judgment, the court doesn't seem to have followed through the logic of its own reasoning, which, as I understand it, was that although the trial judge had said that the underlying transactions to which the first and second charges related were void, and for that reason set the charges aside. Do correct me if I'm wrong, but my understanding is the Court of Appeal overturned the judge in relation to those findings. So according to the Court of Appeal, the underlying transactions for those two charges were good. And the logic of the Court of Appeal's judgment, I would have thought, without any doubt at all, should have been to restore, treat those charges in relation to transactions which were valid as themselves being valid, but subject to the same deeming date as in relation to the third charge, the underlying transaction of which had never been challenged. Is that not the logic of what the Court of Appeal decided? And if it is, why can't we simply now, since the logic seems to be so clear, correct the order made by the Court of Appeal simply to reflect its the logic of its own reasoning?
Well, my lord, I agree with you. That was the logic and was one of the uncertainties which I don't know how to resolve. What you can't do in this separate action.
Well, sorry, just on that, what I'm really putting to you is we can resolve it, can't we? Oh. The logic and reasoning is clear. Why can't we modify the order of the Court of Appeal to reflect their own reasoning?
Well, for the reason you're sitting in different litigation, it's a court of record, and the record which the court has produced stands unless one of the conventional reasons, the slip rule or something like that, somebody makes an application to that court. It's simply, notwithstanding the elevated status which we're at for the purposes of this hearing before the board, it doesn't have universal jurisdiction and can't affect an order of a court which has been drawn up and sealed and is the record. And it would be very tempting to say, yes, of course you can say that, but it's one of the reasons I say that the present position is not at all as clear as was intended when whoever drafted the preliminary issue drafted the preliminary issue. I'm still left in my submission with my core submission, which is that there was a breach of contract, and that the breach of contract survives the registration of the charges, because what the contract says is, and what the mediator has said is, Mr. Hickox is to be treated as an unsecured creditor. And in breach of that provision, he went ahead and relied on the validly registered charges. He could do so because as a matter of, or charge, he could do so because as a matter of public law, he was entitled to do so. But that completely begs the contractual question, which is the core of my submission, as to whether he is liable in damages for doing so. And in view of Miss Small-Davis's agreement with me as to the meaning of clause 3 of the amplification award, I respectfully suggest there's only one answer to that. What leaves me at the moment unclear is I don't know what happened when Mr. Hickox sold the leasehold interest in the property in Lear's Capture Luca property. I don't know which charges he relied on, and if he relied on 2 charges, the registration of which had been set aside by the judge and not altered by the Court of Appeal, because I haven't got the Registered Land Act here and haven't looked at the fine distinction between a registered charge and non-registered charge, I don't know where we are. And
Right.
it's really my submission that because I have a breach of contract, I have a contractual claim for damages, what I invite the board to do is to say, yes, I do have that breach of contract claim, and to remit it to the Anguillan court to give what directions it thinks best, including resolving what appears to me to be material confusion.
But right, I take your point that we're not sitting in an appeal from the first Court of Appeal judgment, and that therefore it isn't open to us to modify the order made in those proceedings. Nonetheless, since the logic of the decision of the Court of Appeal in that case seems so clear, wouldn't, if there had to be an issue resolved, wouldn't it be clear that that court could exercise its powers under the slip rule in order to modify the order that it made to reflect its reasoning? And that being so, why should we not proceed now in these proceedings on the basis that whatever steps might need to be taken to ensure that the order made by the Court of Appeal in those proceedings reflected the actual reasoning of the Court of Appeal in the case, those steps could be taken, but for our purposes, we just proceed on the basis that one way or another, the order could be modified to reflect the reasoning of the Court of Appeal itself.
I'm not sure about the provisions of the slip rule. I recollect that it has a fairly limited time lag provision. I thought it was 28 days. I do not believe it to be an open-ended ability to revise what is an order of a court of record. It is my comment on the slip rule, but I don't know, and it would be the Anguillan slip rule, not the United Kingdom or the England and Wales slip rule. So far as the second point is concerned, I don't know how to say this other than to say this: it's simply not right for this court to override what has been ordered by another court. It may look at it with bewilderment and say it seems very surprising, but if the court has done it and has made an order and it's a court of record, then this court, probably of all courts, has to abide by it and reflect it. And I recognise the unsatisfactory position which we're all in, and I have sought to come up with a pragmatic way of dealing with it, which is to recognise that it is unsatisfactory. I don't think you can resolve it. The proper decision in my submission is to look at the amplification award, where Ms. Small-Davis agrees with me about clause 3, to say that was a prohibition. Hickox is in breach of it, notwithstanding the fact the charges were registered, because the prohibition is against relying on them, not registering them. And the mediator must have intended that to be the case, because if he'd thought the charges weren't registered, he wouldn't have made a prohibition against relying on them. And then for the Anguillan court, look at what should be done and what the implications of the fact that 2 of the charges which Mr. Hickox has apparently relied on are no longer registered, even though the register says they are. I mean, there may be a provision in the Act which says that the register is presumed to be accurate unless otherwise shown, in which case, notwithstanding the judge's order that the registration should be set aside, then Mr. Hickox will have relied on all three charges, which would be valid given the deeming provision and would be valid given the provisions of the Act, if that's what it says, but nevertheless sound in damages because it's a breach of contract.
Yes, thank you.
So my submission is I don't, apart from my invitation to the board to say that my construction of the settlement agreement, the final award and the amplification award are correct, but is then to send it back in a slightly wider form than it would be if the preliminary issue had determined the liability in the way we all thought it would. My Lord Stevens, yes, I'm sorry.
Sorry, just to add to the points made by my Lord Sales, this is a point that is emerging in the course of a reply. And first of all, you would need to obtain permission from the board to raise a new point in reply. And in addition, it is a point that has never occurred to anyone at all in these proceedings up until now. So both on the basis of pleading and also on the basis that this is a reply, but why should we even begin to entertain this point?
Well, if you're not going to let me say it, then I understand the position. But let me make clear, as I already have, why I'm saying it now. And I did wonder whether I should invite the board to hear me before Ms. Small-Davis finished her submissions. I have absolutely no objection to her taking up the remainder of what time remains dealing with it. But the reason it was dealt with by way of reply was because when I was asked the question yesterday, it was put to me that the Court of Appeal had retrospectively validated the registration of three charges. Now, that as a matter of fact is not what actually happened, because we've looked at the judgments now. The reason I was not in a position to deal with it yesterday as I was today is because I did not see this as being the issue in the appeal. It was not something which was referred to by the master at first instance as part of his judicial decision-making process. It's not something which is referred to by the Court of Appeal in its judicial thinking process. And I absolutely acknowledge it is possible I may have missed it in Miss Small-Davis's skeleton, but I did not see it as an issue in the appeal. And therefore, as I said yesterday, I would look at it overnight, and I have looked at it overnight. And in those circumstances, I hope the board will allow me for these submissions to be heard in a formal sense. And if the fault is mine because I have misread Miss Small-Davis's skeleton case, or because I simply failed to see an issue which everybody else should have had seen, then I can say it's my fault, and I apologize. But I'm slightly fortified in the fact that I have discussed the issues in this appeal and the way we, Mr. Friedland's team, are putting his case with other members of my legal team. And none of us saw this as an issue which needed to be addressed.
Well, I would like to just say that it does lead to a question whether you could possibly be right on the final sentence of paragraph 3. What it is that you may not rely on is the prior registration, not on the charge, because it's accepted that the unregistered chargee has rights which are not affected by registration. What you're prohibited from relying on is prior registration. There is no longer any prior registration because of the effect of the order. So one wonders whether there's anything in this point at all.
Well, there is prior, Milady, I agree to an extent, but there is prior registration in relation to the third charge. And what we don't know is what sums of money are attributable to the third charge and the first and second charges, and when the account, unless the matter goes back to Anguilla, there's never going to be a taking of an account. But the taking of account which you referred to will reveal if there is a contractual claim what damages arise under it, and that will involve seeing what actually happened.
You're entitled to ask for an account of the proceeds of sale without disturbing these proceedings. It's something you can do independently. But the position is, with respect, that prior registration has gone. There is no longer any prior registration for the third charge because it is only effective as of the 17th of September, the 16th of September 1997. Sorry, 17th September. There is no longer any registration which could be called prior. That's what you may not rely on. And if that is correct, if that's the view of the board, and obviously you would have to wait for the judgment, we all have to consider it, then this point simply doesn't arise.
Mr. Friedland is not in a position to seek an account of the proceeds of sale. Lear could do that because that was the person who'd given the charge. Mr. Friedland is a stranger to that. He would have to establish his damages claim as a matter of principle, and then on a question of causation, the account would have to be investigated.
Mm-hmm.
Well, now, Mr. Phillips, where have we got to in your submissions? Do you have any other submissions to make?
No, the only points I wanted to make clear, which, and if I didn't say it yesterday, then I should have done, is simply the two figures. I think I've referred to the amount of money which Mr. Hickox realised on the sale as being in excess of 50 million. I'm not sure I quantified Mr. Friedland's claim in these proceedings at just over 14 million. That's simply for the sake of completeness. I have said what I feel I need to say in order to make clear my case, but it may well be that there are further questions which I will gladly deal with to the best of my ability.
Well, what we're going to do now is we're going to take a 5-minute break, during which the members of the court will consult with each other online as to whether we want to hear anything further from either party on any issues.
Thank you, my lord.
So we'll adjourn for 5 minutes at this point. Thank you. Mr. Phillips, Ms. Small-Davis, we have some concerns about the fact that this point has emerged only in the course of Mr. Phillips' reply. We do have reservations as to whether we should venture into this area at all, in the way in which the appeal has been presented. However, having heard Mr. Phillips on the point de bene esse, it being a point taken the first time in reply, it's only right that we should hear you, Ms. Small-Davis, de bene esse too, and we will then in due course consider what account we should take at this point, if any. So, Ms. Small-Davis.
I wonder, Lord Davis, if I could just ask for the judgment and papers concerning the commission for this appeal.
Well, yes, that's another matter I was going to come to at the end.
Oh, I'm so sorry.
But we understand, and Ms. Small-Davis may be able to cast some light on this, that there is a judgment of the Eastern Caribbean Court of Appeal, a judgment on permission dated the 3rd of June 2019. And I don't believe that's included in our papers.
I'm sorry, a judgment of June 2019?
I believe it's the 3rd of June 2019, a judgment of the Eastern Caribbean Court of Appeal concerning permission to appeal to the Privy Council.
For this appeal, my lord?
Yes, my lord.
Yes, my lord.
You're aware of that judgment?
The final leave, giving final leave to appeal to in this matter.
Yes.
Yes, my lord. I am aware of it. There is final leave granted.
And I don't believe that judgment is in the papers that we have at the moment. Don't worry about taking time to look for it now. It would assist us greatly if we could be supplied with a copy of that in due course.
Most definitely. I will assist. I am happy to do so, my lord.
I'm grateful.
Thank you.
Thank you.
And
now,
I'm great.
We'd like to hear you, please, in relation to this new point.
I'm grateful, my lord. I would like to say, first of all, that the position as expressed by my Lord Sales in terms of the logic of the Court of Appeal judgment, the 2010 Court of Appeal judgment in the Hickox versus Friedland matter, is exactly we respectfully submit is exactly right, and that all of the parties have proceeded on the basis that it applies to 3 charges, and that the first 2 charges are the order setting aside is effectively reversed by virtue of the fact that the underlying transactions were ratified by the Court of Appeal. Indeed, in the pleadings in these proceedings proceed on the basis of the existence of the 3 charges being in place. In the the judgment, which is the subject of this appeal from the Court of Appeal in 2018, that court also treated the 3 charges as having been deemed effective from the 16th of September 1997. So it is entirely a new point, and one in which the parties have conducted themselves in a manner in which they have accepted that the reality of the effect of the Court of Appeal, 2010 Court of Appeal judgment, was that the order setting aside, the order made by Justice George Cricket setting aside the first 2 charges on the basis that the underlying transactions were void for want of authority was of no further effect. It appears to have been an oversight in the Court of Appeal in not making that formal order. Your lordships have already noted all the lawyers who were involved in those proceedings, and it has been well known to us for all these years, and all the parties have conducted themselves as I have said. In any event, I do not believe that it is a matter that will derail our consideration, the court's considerations of the substance of this appeal. Certainly, my friend Mr. Phillips accepts that the 3rd charge remains in place in any event. And the 3rd charge, you will see it recorded at page, you can find it at page 157. And that 3rd charge was in 1997 for a principal amount of $7,449,000 United States dollars at an interest rate of LIBOR plus 2% per annum. So that charge by itself was of a substantial amount. And I can say that the public auction, it was a matter of public record, and in fact the record of the Anguilla land register reflects that the property was transferred by sale at a public auction for $13 million. At the auction, there was a single bid of $13 million, and that was the bid that succeeded. And so it is not correct that it was over $50 million. That is not correct. I accept that Mr. Phillips may have did make an error in that statement. The amount was $13 million.
That's 1-3.
1-3.
Thank you.
No, we have not done an accounting. It is true that we have not done an accounting, but I think that the court can consider $7.5 million United States dollars with interest at LIBOR plus 2% from 1997 to 2012. When you compare that Mr. Friedland's debt, originally in the amount of $4 million in 1998, by the time he got to 2012, it had reached $9 million at an interest rate of 5.43%. The point I'm making is that even if Mr. Hickox was only entitled to exercise his rights under the 3rd charge only, the position would not change in reality.
Yes.
I also wanted to make the point again that in any event, Mr. Hickox was restrained from prior registration of the charges, and that the mediator in his final award and in the amplification award acknowledged that Mr. Hickox was entitled to proceed as an unregistered chargee. So he was entitled, if you look again at the mediator's final award, which is at page 136, he said there, 135, he said there at on issue number 2, Mr. Hickox was restrained from pursuing his remedies as a registered chargee, and he could take legal action to collect the debt owed to him only as an unregistered chargee. I think the issue number 3, the finding on issue number 3 is also helpful to us in the consideration of what has emerged in this reply, and that is that even then the mediator held that to the extent that Hickox is permitted under applicable law to pursue foreclosure action as an unregistered chargee, the mediator finds that the settlement agreement does not require Friedland to be paid ahead of Hickox. So Mr. Friedland was not being given any priority over Mr. Friedland, over Mr. Hickox, even whilst Mr. Hickox was in the category, the status of an unregistered chargee. And I must again bring us back to clause 6C, which acknowledged Mr. Hickox as an unregistered chargee and stipulated that any charge that Mr. Friedland got was to be expressly stated to be subordinate to Mr. Hickox's. So the landscape does not change. There's no advantage to be gained by any the apparent confusion as to whether or not the first 2 charges remained or are effective as registered, or they remained set aside as per the order of Justice George Freaky, even though no one has ever treated it as such, and that Mr. Friedland would remain in a situation of being a subordinate to Mr. Hickox's 3rd charge only, or even him as an unregistered chargee, Mr. Friedland would still remain subordinate to Mr. Hickox. Again, when we look at I want to deal also with the submission that has been made that Mr. Friedland was not a party, and so the agreement, the judgment of the High Court was not binding on him, even though it was a judgment in rem and applied to everyone. It did not bind him personally. Mr. Friedland has been described as having an equity interest. Mr. Friedland was a 100% equity owner of LIR. I am saying that LIR was effectively his alter ego. He's not a person who had an equity interest. He had the equity interest. And therefore, in answer to the question that was put to my friend Mr. Phillips as to the reason why Mr. Friedland did not himself join in the proceedings, there is no explanation for it. He obviously treated LIR as his alter ego. My friend Mr. Phillips took your lordships back through the judgment of Mrs. Justice George Creaky, and to state that it is only in paragraph 118 that there's been any reference to dealing with the charge. I would like to remind your lordships of the fact that the issue relating to setting aside the registration of the charge was one raised by LIR in a counterclaim, and that is set out in paragraph 6 of the judgment, which is to be found at page 184. So at paragraph 6, the judge recites, LIR in response to Mr. Hickox's claim in its repleted defense and counterclaim comprising 155 paragraphs, challenged whether the loans or advances evidenced by the promissory notes were in fact made and contends they were made, etc. LIR also challenges the validity and or enforceability of the first and second transactions for want of authority, or alternatively that same are voidable, for breach of fiduciary duty by Mr. Hickox as a director of LIR at the material times, LIR also seeks an order directing the Registrar of Lands to cancel the registration of charges recorded against LIR's leasehold interest in favor of Mr. Hickox pursuant to the first and second transactions, as well as a third charge pursuant to a standby agreement between the parties. So when your lordships heard that the court had followed the issues that set out by Mr. Henriquez was comprehensively setting out the issues that arose both on the claim and on the counterclaim. And the issue relating to setting aside the charges was raised by LIR for the reasons we have already stated and which are set out in paragraph 6, and primarily as it relates to the third charge by reason of the breach of the settlement agreement. That is what the judge had in mind. And I don't think it is fair, and it is certainly not correct, to say that the learned judge did not address her mind to the sanction imposed by the mediator, because in paragraph 118, the end of the page 253, where she says it is common ground that Mr. Friedland reacquired the LIR shares by auction after the payments under the settlement sum were not met. It is only at that time that the terms of the settlement agreement may be said to have, to some extent, become spent. And then when she says the sentence about thus any registration by Mr. Hickox ought only to be effective as from the date of the sale of the LIR shares, all of that, those facts that she has stated, would have been in the, not even the final agreement, it would have been in the amplification award. The date is only set out in the amplification award. That's the only place where the date is stated. It is not stated in the final award, and obviously it's not in the settlement agreement. And Mr. Phillips agreed yesterday that the judge had indeed been given the amplification award as directed by the mediator. So that it is not fair to the judge to say she did not have the sanction in mind because she was fully aware of it, having had the amplification award. The fact that she does not cite it in the paragraph does not mean that she did not have that in mind. She clearly did, because she uses what I would refer to as the end of the sanction date, the 16th of September 1997.
Well, Paul Davis, I think we've perhaps wandered a little bit away from the specific point of the first and second charges.
Yes, and I'm grateful. I think
please forgive me. We have at least heard your submissions in relation to that matter. Thank you.
Yes, ma'am.
Mr. Phillips.
Thank you. Thank you.
On that specific matter, anything you want to say in reply?
My lord, no. I believe I've made my case clear.
Very good. Thank you.
But I have a question.
But Lord Sales has a question.
Yes.
Yes, I think in relation to these matters that we're trying to clarify, I should just draw attention to paragraph 13 of the Statement of Facts and Issues at page 356 in the bundle. Paragraph 13 is the one that deals with the High Court judgment and then the first Court of Appeal judgment. At the end of that paragraph, there's the sentence, the effect of the Court of Appeal judgment is that as a matter of Anguilla law, 2 of the 3 Hickox charges were valid as from the date of their registration in January 1997. Now, as I understand Ms. Small-Davis' case, and indeed, as I've understood Mr. Phillips' arguments, they have in fact both been predicated on the idea that the first 2 Hickox charges should, by the logic of the Court of Appeals judgment, be treated in the same way as the third one, that is to say, deemed to be registered, deemed to have been effective as from the 17th of September 1997. In other words, without seeking to draw a distinction between the charges. And since we've got the Statement of Facts and Issues in the terms we have it, I thought I'd better just clarify that both parties are satisfied that we approach the appeal on that basis.
Mr. Phillips?
Well, I confess, looking at the end of paragraph 13, I don't know why it says 2 of the 3 charges were valid. as from the date of the registration. I'm obviously I'm a party to the facts, statement of facts and issues, but I don't understand that. But how we said that, because if anything, if it isn't all three, it would be just the one, because of the fact the Court of Appeal didn't reverse the trial judge.
Well, there was no appeal in relation to the trial judge's order as to the validity of the third charge.
No. So I would expect this to say the effect was that a matter of Anguillan law, one of the three charges were valid, or taking Lord Sales's position, all three were. I don't understand why it says two.
It's a slightly odd way of expressing it, but it has been the position of both parties throughout this appeal that there were three valid charges.
My Lord, what Miss Small Davis said is right, that if you read the statement of claim, you will see that it's predicated on the basis that there were three valid charges and Mr. Hickox was acting in breach of contract in enforcing all three. It's because I looked at the judgments with care as a result of what I was asked yesterday, that what I've referred to as the conundrum emerges. And I didn't do it before, as I say, because it wasn't something which featured in the Court of Appeal judgment as part of its reasons, and there's no respondent's notice seeking to rely on additional grounds.
Well, you've explained how it came about, Mr. Phillips, and of course we understand that. Thank you. If there are no further questions for counsel, then it remains for me to thank counsel very much for your particularly helpful submissions. The panel's been greatly assisted by the submissions that have been made yesterday and today. We're also very grateful to those who sit behind you metaphorically. We realise that a great deal of work has gone into the preparation of this appeal, which is very much appreciated. The board will now take time to consider the advice which it will tender to Her Majesty. The hearing's now
Thank you,
very much.
Thank you.